This is an open hearing of the independent inquiry into matters relating to Afghanistan. Please could I ask you to ensure that all mobile telephones and other personal electronic devices are either switched off or in silent mode. Please may I also draw your attention to the fact that the Chair of the inquiry, the Right Honourable Sir Justice Haddon-Cave, has made a restriction order in relation to the conduct of those who are attending the hearing. The full order is displayed on the inquiry website and on the door of this court and of the media annex, but I will summarise its purpose. The first part of the order, which applies to this and to all future hearings of the inquiry, prohibits any person from making an audio or video recording of inquiry proceedings from within the hearing rooms without the express permission of the Chair. Furthermore, no person may take a photograph in any room in which inquiry proceedings are taking place and at a time the inquiry is sitting without the express permission of the Chair. For the avoidance of doubt, both of these prohibitions extend to the hearing in the media annex. The second part of the order, which applies to the hearing scheduled to take place today, 11th October 2023, arises as the live stream of these inquiry proceedings via YouTube will purposely be subject to a 10-minute delay. It is prohibited that any person may disclose, publish or broadcast in any form or by any means anything that is said or done in the inquiry hearing room until 10 minutes after it has taken place. If an application is made for a restriction order in relation to anything that has been said or done in the inquiry hearing room, in that preceding 10 minutes, anything that was said or done during that period is subject to a restriction order prohibiting its disclosure, repetition or duplication until the Chair has finally determined the application. All of the above orders are subject to a penal notice. This means that any breach of any element of the restriction orders may be certified to the High Court or the Court of Session, who will have the power to fine or imprison anyone found to have been in breach of the order. Court rise. As part of the independent inquiry relating to Afghanistan. The hearing is before Lord Justice Haddon-Cave, the Chair of the inquiry.
Good morning, everybody. Mr. Hermer.
Thank you, sir. Sir, we are grateful for the opportunity to address you at the outset of this inquiry, to set out our analysis of the evidence in our possession as of today, and to highlight to you and your inquiry team matters of grave concern that we consider require rigorous investigation by you and your team. And as I said at the last preliminary hearing before you, sir, we are grateful for the professionalism, for the dedication and the courtesy shown by you and the inquiry team, including not least the efforts made at short notice to ensure that the broadcast of these proceedings is simultaneously translated into Pashto for the benefit of our clients. Thank you, sir. Now, over the course of the next few hours, I will outline allegations of the utmost gravity. I will seek to highlight evidence capable of suggesting that members of the SAS were applying a practice of unlawfully killing Afghan civilians. In other words, so we are absolutely clear, evidence that they were conducting a campaign of murder. Not only, obviously, a crime in domestic law, but a war crime amounting to grave breaches of the Geneva Convention. And what is more, I will seek to highlight that there is evidence capable of demonstrating that this practice, or at least suspicion that this practice was taking place, was known to senior officers within the SAS and to senior personnel within the Ministry of Defence, who not simply did nothing about it, of course itself unlawful, but in some circumstances actively sought to prevent adequate investigation of murder. Now, you may come to conclude, depending, of course, sir, on the evidence that you receive, that their action and inaction allowed suspected war crimes to continue. They enabled suspected perpetrators to escape accountability, and they contributed thereby directly to further unnecessary and avoidable losses of civilian lives. Now, in respect of what I'm going to outline today, it's very important at the outset to make one thing plain. The allegations that I'm going to set out are not the construct of lawyers, they're not the construct of human rights organisations or media reportage, nor are they, in the main, premised upon the accounts of victims and their family members. Rather, I want to stress that the outline that I am going to give is almost entirely based on the military's own documents. Documents that the Ministry of Defence spent many years trying to prevent ever coming into the public domain. And this includes, as set out by Mr. Glasgow King Counsel, very serious contemporaneous concerns within the SAS itself that units on the ground might be unlawfully killing civilians and seeking to cover up wrongdoing. Now, flowing from this is another associated point that I want to make at the outset. No one doubts, of course, that war is brutal, and that often the very point of an operation is to engage and to kill the enemy. But what is important to stress about many of the expressions of concern that we're going to see on the documents, for example, the high number of deaths in operations or the disparity between bodies and weapons, is that these are concerns expressed by members of the special forces themselves. They are not a reflection of civilian naivety. Serving military personnel with extensive experience of the grim and bloody realities of war were the ones expressing alarm about what was going on. So this inquiry is the result of many years of unwavering commitment by the bereaved families, and in particular by the Saifullah and Norzai families. Their struggle to establish the truth of what happened in the night raids conducted by SAS units in Afghanistan has been hampered over more than a decade by a closing of ranks in the British Army and Ministry of Defence, by a culture of secrecy, self-protection, deference, defensiveness, by delays in investigations, by failures to pursue critical lines of inquiry, and by the apparent concealment and destruction of relevant evidence. The hope of the bereaved families is that your inquiry represents the end of the wall of silence and the obstruction that has confronted them over the last decade. They sincerely hope that you, sir, with the powers bestowed on you by the Inquiries Act, will finally shed light on the conduct of UK Special Forces in Afghanistan and the circumstances of their loved one's death. The path to get here has been, as I have said, long and arduous. The Norzai family first brought litigation in the English courts in 2013, but were told that their challenge was premature as military investigations into the incident were taking place. Almost a decade later, no adequate, we would suggest, investigation had occurred. And the most recent Saifullah and Norzai judicial reviews, challenging the lack of an Article 2 compliant investigation into the deaths, were issued as late as 2019 and 2020. And it was these proceedings which, after 3 years of court proceedings, and alongside the committed reporting of the allegations by BBC Panorama and Sunday Times, ultimately led to the establishment of this inquiry. And significantly, it was the disclosure of thousands of pages of documents by the MOD in the context of those claims that rendered the need for this inquiry irresistible. The contents of that disclosure are both revealing and deeply shocking. As I shall explain, those documents contain extensive contemporaneous evidence of suspected extrajudicial killings by the SAS in Afghanistan. They also contain extensive contemporaneous evidence of apparent attempts to cover up wrongdoing, ranging from the destruction of evidence and the coaching of witnesses to the turning of blind eyes and the credulous acceptance by those responsible for military discipline of implausible and often wholly incredible accounts of events. And these documents are extensive, they are detailed, and they are extremely disturbing. It's important to stress, and it's important to stress at the outset of my submissions, that these documents do not only paint a picture of wrongdoing and complicity. They also show that there were individuals within the Special Forces and within the Ministry of Defence who were deeply concerned about what was going on and who sought to make those concerns known to the powers that be. They are individuals with a conscience who sought, in short, to do the right thing. And the inquiry represents a forum in which the voices of those individuals, good, decent, professional soldiers, officers and officials, can be properly heard. Equally, it is clear from the documentation that the work of the RMP was conducted by many dedicated individuals working in difficult conditions and with a determination to get to the truth. And those individuals too should be commended. That is not to say, though, that the acts and admissions of some members of the RMP and external advisers do not call for intensive and critical scrutiny, let alone should good faith be allied with an adequate investigation. So the bereaved families are heartened by the fact that many soldiers, officers and officials appear to have already approached you and your inquiry team. We sincerely hope that others come forward to assist this inquiry in its vital work. There may be a range of reasons why individuals may choose to come forward now. Many, no doubt, will do it because it is simply the right thing to do, to tell the truth and ensure that crimes are reported, putting the best values of our country above loyalty to a regiment. For others, it may be simply self-interest in the knowledge that others within their regiment or in their organisation may already be providing testimony to this inquiry. The experience of the Brereton inquiry in Australia shows that a wall of silence can be very hard to break. But once a single brick is removed, the whole edifice is capable of collapsing. Now, I dare say that a plea from those that I represent will carry far less weight than this inquiry's call for evidence. But many of those who may be listening today and following these proceedings and who have relevant evidence to give will themselves be parents, brothers and sisters. They may reflect on the agony that the absence of certainty about a death of a loved one brings to those left behind, the anguish that it causes, the inability to move forward. And on their behalf, can I simply say that it is never too late to do the right thing. The bereaved families, sir, are grateful for your commitment to make speedy progress with this inquiry. They've waited long enough already. But their primary concern, and we are sure that it is yours as well, is that this inquiry is thorough, that it gets to the bottom of what happened, and that it does it in a way that ensures lessons are learned for the future. And the importance of this inquiry to all participants, is that it establishes the truth, whatever that truth is. As lawyers in times of uncertainty, we often look for guidance to the thinking and the learning of legal greats. And Lord Bingham encapsulated what the purpose of an inquiry such as this is in the case of Amin. And Lord Bingham said that the purposes of an investigation are clear. He said, and I open the quote, that it is to ensure, so far as possible, that the full facts are brought to light, that culpable and discreditable conduct is exposed and brought to public notice, that suspicion of wrongdoing, if unjustified, is allayed, that dangerous practices and procedures are rectified, and that those who have lost their relative may at least have the satisfaction of knowing that lessons learned from his death may save the lives of others. I end his quote there, and reflect that there is an obvious benefit in identifying the culpable and exonerating the wrongly accused. And if there is a thorough, fearless and effective investigation, and if it concludes that there was no wrongdoing, then that is a conclusion that the bereaved families will accept. But if your inquiry concludes that there is credible evidence that murders took place and that there was a cover-up, then the bereaved families seek proper accountability for those actions, and proper accountability in those circumstances would require further criminal investigation and prosecution of the implicated individuals by law enforcement authorities, fully independent, properly resourced, with relevant skills and specialist expertise to prosecute what are complex, serious crimes. Proper accountability is not, however, limited to the prosecution of individual perpetrators, if that's where the evidence takes you. The bereaved family's personal experiences are fundamental to this inquiry, but they form part of a much bigger institutional question at the core of your terms of reference, sir. How the British military conducts itself on operations abroad. How and whether it maintains the discipline, order and lawful behaviour of its soldiers, and what it means for the reputation of the United Kingdom in the international sphere. Proper accountability must therefore involve not only the soldiers on the ground, but those who are responsible for their management and their oversight. It must reach beyond the prosecution of criminal suspects to encompass a root and branch review of the culture, practices and oversight of special forces, to establish how such wrongdoing, if established, was allowed to occur and continue unchecked, and what changes are required to ensure that it never happens again. And I want to emphasise at this point, sir, that the bereaved families do not see this as an opportunity to simply criticise and blame the military. Far from it. Rather, they recognise the inquiry's importance in upholding, re-establishing and ensuring the reputation of our military and the rule of law. If the allegations of unlawful killings and cover-ups are true, the soldiers responsible and the officers who permitted those actions to continue unchecked have behaved contrary to everything that our military stands for and everything that it seeks to protect. Their conduct, if the allegations against them are true, erodes the standing of the British Armed Forces and threatens the reputation and safety of the very many good and decent, brave soldiers who serve this country. It is by shining a light on what happened that this inquiry may re-establish that standing and ensure that lessons are learned for the conduct of future operations abroad. We don't underestimate, sir, for one moment, the enormity and complexity of the task that you are undertaking, born not least of the sensitivity of the subject matter, of the materials you must analyse, the time period over which the inquiry stretches, and no doubt the multiple lines of inquiry that you and your team are pursuing. And arising out of that complexity, can I just make 3 observations? Firstly, as the inquiry is well aware, notwithstanding that you are examining the activities of United Kingdom Special Forces, which gives rise to issues of obvious sensitivity, it remains essential that the participation of the bereaved families is maximised. That's not a matter, I would respectfully submit, sir, of grace and favour, but it's an obligation, a lawful obligation under both the Inquiries Act and under the Human Rights Act. And we would respectfully submit that at every turn, the inquiry should be alive to ensuring our participation is maximised, be that by way of hearings, by way of disclosure, by way of communication. And this in turn maximises the ability of the bereaved family to assist you as well as fulfilling the lawful obligations imposed upon this inquiry. And so we say with respect that this opening today should in no sense be taken to be the high point of the bereaved family's participation. The second observation, sir, is that in addition to ensuring the participation of the family, the inquiry needs to ensure that its work, not least its workings and its conclusions, are available for public scrutiny. There are obviously exceptionally difficult balances to be struck when much of the evidence before the inquiry will be in secret. But with allegations this serious, the nature of that secrecy, in fact, only serves to reinforce the need for the inquiry to be able to explain its workings and its conclusions, whatever they are, as fully as possible. And thirdly, sir, can I observe this? The inquiry's mandate is to ascertain whether there are credible allegations of an exceptionally serious crime. And we recognise that the inquiry will need to balance the very delicate task of fearlessly discharging that obligation, whilst ensuring that nothing is done that might prejudice any future prosecutions in the event the potential criminal wrongdoing is uncovered. Now, we know that this is something that your inquiry team is exceptionally well placed to consider, but it is, though, a matter that we have thought appropriate to openly ventilate before you this morning. So that's what I wish to say by way of general introduction. I hope it assists if I tell you how I'm going to divide the remainder of my opening. And I'm going to divide it, if I may, into 6 main parts. I'm going to begin by providing an overview of the night raids in which the bereaved family relatives were killed. Now, these are going to be the same incidents as you've already taken to by my learned friend, Mr. Glasgow, and I am going to take you to some of the same documents, all of which were disclosed to us in the judicial review proceedings. But I will seek to do so in a chronological order and to draw some discrete and distinct points as we go along. So that's part 1. Part 2, I'm going to address some of the key features of the factual background relevant to your assessment as to whether or not there's credible evidence of a campaign of extrajudicial killings, EJKs, during the relevant period. In part 3, I'm going to address the extent to which there's credible evidence that suspicions of EJK were covered up. In part 4, I'm going to address concerns as to the adequacy of the RMP's investigations. In part 5, I'm going to address our concerns about the evidence of a continuing cover-up by the Ministry of Defence during the judicial review litigation. And finally, I'm going to address some issues going to systemic and cultural failures. So with your leave then, may I turn to the incidents in which the bereaved family relatives were killed. As we all know, the subject matter that underpins this inquiry is the conduct of SAS soldiers during a series of night raids in Helmand Province, Afghanistan, while on tours of duty between 2010 and 2013. Each of those raids in question resulted in the lives of Afghans, some of whose families have been given core participation status in this inquiry. To give you the numbers, there are 14 bereaved family core participants from 9 different families who between them lost 33 of their loved ones in 7 SAS night raids. Now, you, sir, are of course looking at many more similar raids and death that occurred over the same time period covered by your terms of reference. And the core participant families represent only a partial subset of the families affected by the conduct in the relevant period. I would, though, like to take this opportunity on behalf of the core participant families to name each of their family members killed in night raids by the SAS, recognising that their lives and their deaths are foundational to this inquiry. So I'm first going to turn to those who were killed on the night of the 29th of November 2010. And they were Mohammed Ibrahim, who was aged 55, Sami Ullah, who was aged 14, Nissa Ahmed, who was aged approximately 18, Saifullah, aged approximately 22, Izzatullah, approximately 42 years old, Shams Ullah, approximately 33, and Haji Wasir, aged approximately 38. I'm so sorry, the last were of course killed on the 7th of February 2011. I'm going to turn then to the 9th of February 2011. Saeed Mohammed, aged approximately 35, Noor Mohammed, aged approximately 34, Ahmed Shah, aged approximately 32, Abdul Zahir, aged approximately 23, Mohammed Tahir, aged approximately 15, Ahmed, aged approximately 46. I turn then to the raid of the 16th of February 2011, and those killed were Abdul Khalik, who was in his early 50s, Saddam, who was aged approximately 22, Atta Ullah, who was aged approximately 24, and Ahmed Shah, aged approximately 20. I turn next to the raid of the 12th of March 2011, and those killed were Asad Ullah, aged 29, Saifullah, aged 16, Zabi Ullah, aged 28, Khalil Ullah, aged 21, Nakbib Ullah, aged 17, Ismat Ullah, aged 31, Ashok Ullah, aged 14, and Muhammad Ullah, aged 18. I turn then to the raid of the 6th of August 2012, and those killed were Hussein Uzbakzai, aged approximately 24, Rukak Mullah Mohammed Halim, also aged approximately 24, Mohammed Wali, aged 26, and Mohammed Juma, aged 28. And I finally turn, sir, to those who were killed on the 18th of October 2012. Ahmed Shah, aged 12, Mohammed Taib, aged 14, Naik Mohammed, aged 16, Fazl Mohammed, aged 18. So I'm going to turn now to the facts of the 7 raids, and as I've explained, I'm going to take it in chronological order, because so when seen chronologically, even though this is just a small subset of the raids that you are considering, one begins to see patterns, and we can see those patterns for ourselves, and then we can cross-refer that in real time to what the experts within SAS Command were thinking was going on and what was going wrong. So this gives us taking it chronologically, gives us an insight, and it allows us to see patterns and to cross-refer that to what was being perceived on the ground at the real time. So I'm going to start with the incident and the raid on the 29th of November 2010. It was the first example that Mr. Glasgow took us to. It's also known as Objective 3. And this was a night raid, as we've seen, in the Naroz village in Helmand, in which Mr. Abdul Wali's father, Mohammed Ibrahim, was killed. Now, we've seen some photos of him from the raid, but I want to show a photo of him now, if I may, on the screen. This is, as you can see, is a pre-raid photograph. Now, the SAS detained all the men who were in the family compound, including Mr. Wali's father, 2 of his brothers, and 1 of his cousins. And his father was selected to be sent back into the building, where he was shot dead, so it is said, after pulling out a concealed hand grenade from behind a curtain. Now, this was the first of 4 times in the 7 core participant night raids in which the SAS claimed they'd killed Afghan men because, after detaining them, rendering them hors de combat, and sending them back into the building, they are alleged to have suddenly sought to use concealed weapons against their SAS captors, a practice that quite literally, as we will see, some in the chain of command found quite unbelievable. Now, Mr. Ibrahim's death caused serious concerns which were raised with the British authorities by the provincial governor of Helmand, Governor Mangle, and the then President of Afghanistan, President Karzai. That's when Mr. Ibrahim had been a deputy police chief and then a district governor. And there was accordingly a high level of interest in his death, including from the media and the ISAF chain of command. But night raids of this sort continued. In particular, though not involving core participant families represented in this inquiry, further incidents involving suspected extrajudicial killings took place on the 28th of December 2010, in which 1 person was killed, 9th of January 2011, 2 people killed, 15th of January 2011, 1 person killed, 19th of January 2011, 3 people killed, 24th of January 2011, 6 people killed. I'm going to move to the next incident along the timeline, which is the one that occurred on the 7th of February 2011. It was again Mr. Glasgow's second example. As we're going to see, it was also known as Objective 1, and it took place in the Mataki Dashti region, again in Helmand. A total of 9 people were killed on this raid, sir. They included 2 of Mr. Habib Alizar's sons, Sami and Nissa, and 2 of Mr. Haji Shamsullah's brothers, Saifullah and Izzatullah, as well as 2 of Mr. Abdul Wasi's brothers, Shamullah and Haj Wasir, as well as 3 others. Now, official reports, and we've seen some of these, the operation summaries, allege that shots were fired from within the guest house on the night of the raid, leading to what was said, shooting dead in self-defence. However, the circumstances, as present themselves on the evidence, throw a much more suspicious light than the documents suggest. The bullet holes on the walls of the guest house are in clusters close to ground level, supporting a suggestion that the men were in bed when they were shot. And some of the official accounts refer to possible fratricide which is meant by which is meant the killing of Afghans by Afghans rather than British soldiers, which you're going to see, sir, is a recurring theme in some of the SAS's reportage of their own raids. But I'm going to suggest it's a highly implausible explanation given for the large numbers of deaths that it is sought to justify. And this raid was one of many cases where the numbers of weapons said to have been found by the SAS and used as the basis for justifying lethal action was fewer than the number killed. And the position of some of the weapons in the scene shown in the photographs suggests that this could be an example of what we're going to see in the documentation described as dropped weapons. That's the practice of soldiers planting weapons next to bodies to make it appear that unarmed men they had killed in fact posed a risk to life. And the Royal Military Police recorded that written accounts provided after the incident by the soldiers involved what they described as cut and paste statements. That meant, in their own words, that investigators could not accept the veracity of the accounts. Those are the accounts given by the SAS soldiers. I'm going to return a little later to dropped weapons. Governor Mangle, it should be said, also raised a concern about this incident, and he asked for an investigation. But the family has heard nothing from British Armed Forces or the UK government since that incident. I'm going to move down the timeline, if I may, and turn to the next raid, which occurred on the 8th and 9th of February 2011. It was again Mr. Glasgow's third example. And this resulted in the deaths of a further 7 men and a 15-year-old boy. Those I represent, Mr. Darwood lost 3 brothers, and Ahmed, Abdul and Mohammed, and a cousin Ahmad. Mr. Muzammil's brother, Saeed Mohammed, and a cousin, and Noor Mohammed, were also killed, together with 2 other men. And this is an incident that, as we've seen, took place again in Helmand, in Khan Anu, in a compound owned by Mr. Muzammil and rented by Mr. Darwood's family. The SAS arrived at the compound and approached the guest house, where 7 men were killed. The official reports say that as British soldiers approached the guest house, one of the men came out and started shooting at them, so the soldiers returned fire. Allegedly, 4 of the 7 men were shot in confusion by 3 other Afghan men rather than by British troops. Now, we would ask you to consider whether that is a plausible or implausible explanation, whether seen in isolation or seen in context of the wider pattern of evidence that's before you. But it is an event that is, in any event, undermined by inconsistency in the SAS's own records. None of the bodies were found outside the guest house. Only 3 AK rifles were said to have been found within it. And some of the soldiers' accounts do not record that anyone came out of the guest house shooting. The SAS unit on that raid then moved to the main house and ordered everyone to leave and detain the men. Mr. Darwood's brother, Ahmed Shah, was then sent back into the house. Soldiers' account of the incident alleged that he pulled an AK-47 from behind a curtain, again, and was shot before he'd had the chance to use it. This is what we would submit is another example of what became an all too familiar story, and another occasion in which the bodies exceeded the number of weapons apparently found. Now, the soldiers' account of this incident were met with disbelief by senior members of the United Kingdom Special Forces. On the day of the incident, a Special Forces Lieutenant Colonel, who has the cipher N2107, sent an email referring to the incident and expressing disbelief at the official account of what had happened. We put the email and his words on the screen. He said, "It is quite incredible the amount of bees, that Afghan males, bravos, that the units send back into a building, who then decide to get weapons and grenades and engage the unit, knowing that it will achieve nothing. Why come out? Why not wait for the unit to come into the room and engage them in a confined space where there is a greater chance of causing casualties?" We then see that he added bluntly, "Whilst murder and the special forces have oft been regular bedfellows, this is beginning to look bone." N2107's colleague replied to an email which referred to stats from headquarters, proudly comparing the unit's extra judicial killing rate to PF1, which we take to be a friendly force of another country, and claiming that they kill more insurgents. In other words, this appears to be evidence, through reportage, of the SAS boasting about their superior tally of kills. Now, he shared N2107's disbelief of the official count of the incident, and he wrote, "I find it depressing that it has come to this. Ultimately, a massive failure of leadership. If we don't believe this, then no one else will. And when the next WikiLeaks occurs, then we will be dragged down with them." Now, this incident is one of the only a handful of operations which were then examined in detail by the RMP in Operation Northmoor. And the RMP's analysis underscores the deeply suspicious nature of the incident. In their executive summary, they observed, for example, that the SAS's official narrative of the incident does not match the SSE, that sensitive site exploitation. For example, it was noted, the absence of material, blood, where you would expect to see it, raises questions given the account in the executive summary. The position of the alleged EKIA appears to be at odds with the narrative, inside the house versus outside. To the reasonable person, SSE are alarming. The RMP noted that an account provided by one of the soldiers present on the operation would potentially tie what can be seen within the SSE photos: fighting aged males executing on target, not holding weapons. Going to move, if I may, sir, along the timeline. Again emphasising, we're only looking at the 7 cases in which I represent bereaved families. These are no more than a subset of the wider materials that you will be in possession with or are going to come into possession of. And the next incident is the incident of the 16th of February 2011, and it concerns and relates the deaths of 4 family members of Mr. Saifullah in an operation that was codenamed Tyburn. Now, I should mention, sir, and I do this by an aside, that we've received no insight into how operations are codenamed. But it is somewhat striking that the operation was codenamed, shares a name, with this country's most notorious execution site at Tyburn. It's also striking, and again I do this by an aside, merely an aside, and you'll understand that, sir, that Operation Sestro, which we're going to turn to a little later, carries the Latin name for grave, or a tool for creating graves. Now, as you know, sir, it's Mr. Saifullah who had the bravery to bring the claim for judicial review that resulted in this inquiry. And he is desperate to uncover the truth about what happened to his relatives and how their deaths have been handled since. And so Mr. Saifullah has recorded a short video clip in which he wishes to address you. And it's been translated, and you'll see subtitles.
بسم الله الرحمن الرحيم زما نوم سیف الله د عبدالخالق زوی اصلي د هلمند ولایت د لښکرګاه ښار ښاروالۍ اوسېدونکی یم چې فعلاً هم په لښکرګاه ښار کې ژوند کوم او خپل د کورنۍ ورځنۍ چارې پر مخ بیایم. د 2011 کال د فبروري په 14مه نېټه د برټانوي ځواکونو د شکني عملیاتو په نتیجه کې چې زموږ په کور یې ووهلل، په نتیجه کې زما پلار حاجي عبدالخالق، زما دوه وروڼه هر یو لکه صدام حسین، عطاالله او زما د اکا زوی احمدشاه ووژل شول. تر وژل کېدو مخکې زموږ کورنۍ ډېر ښایسته ژوند درلودی. موږ ډېر خوشحاله، ډېر ښایسته ژوند درلودی. همالته په هغه ځای کې کوم وخت چې دا زما وروڼه و، پلار د اکا زوی ووژل شوله، د هغه وروسته موږ ټوله کورنۍ په رواني مشکلاتو باندې اخته شولو. ټول د اعصابو د خوا څخه مشکل پیدا کړ، په رواني مشکلاتو باندې اخته شولو. زموږ موقعې د هغه وخته څخه تر اوسه پورې د زنګنو د ګونډو درد مو تېر شوی دی چې 2-3 واره مو تر پټي وو، کراچي وو، لکه په افغانستان کې کوم ډاکټرانو ته وزارېدولي وو، نتیجه هم ته ورکړې. د عطاالله ښځه چې د هغه وخته څخه د اعصابو مشکل ورته پیدا شو، هغه هم همداسې پر ډېرو ډاکټرانو حتی د پاکستان پورې بیولې ده، خو تاسې معنا تر اوسه پورې نتیجه نه ته ورکړې. نو دا یو ډېره سخته او ډېره غمګینه او ډېرې دردونکې شپه وه، د کوم وخت څخه چې دغه چاپه واقع شوې ده او دغه برټانوي ځواکونه زموږ کور ته راغلي دي. نو د هغه وخته څخه تر اوسه پورې په موږ باندې خوبونه ډېر ارام دي او زموږ خوبونه له منځه تللي دي. هغه عادي حالت کې نه دی، موږ بس دا وخت یو ویرونکي خوبونه وینو، دا وخت مشکلاتو ډک خوبونه وژنو. موږ او کورنۍ ټول په داسې یو تکلیف اخته وو. کوم وخت چې زما وروڼه ژوندي وه، په هغه وخت کې زما ورور دلته په لښکرګاه ښار کې د پوهنتون په 3م سمسټر کې و، عطاالله او صدام حسین همدغه کال د تعلیم او تربیې ښوونځي ته کامیابه شوی و. زما پلار چې و د دهقانۍ او د بزګرۍ ژوند چارې یې پر مخ باندې بیولې. بیا چې کوم ځای پېښه وشوله، موږ هر څه د لاسه ورکړل. موږ ډېر ستړي شولو، ډېر ضعیف شولو، ډېر درد شولو. نو زموږ د پلټنې، زما او زما کورنۍ د پلټنې د رسمي ټیم څخه هیله او غوښتنه کوو چې موږ په حقیقت پوه کړي چې ولې په کوم اساس موږ سره دومره ظلم وشو، او حتی تر اوسه پورې موږ په دې نه یو پوه شوي چې ولې داسې سخت ظلم موږ څخه وشو. السلام علیکم.
So before turning to the incident itself, which, as I said, occurred on the 16th of February of 2011, it is important to note that 2 days earlier, on the 14th of February, another incident took place in which 3 Afghan men were shot dead by the SAS during a night raid. Now, once again, in respect of this earlier, the 14th of February raid, contemporaneous document shows that the official account of this incident was met with complete disbelief by senior military personnel. And we can see that in an email sent on the day of that incident of the 14th of February. N2107, one of the officers whose email I quoted just a moment ago, sent an email referring to this incident and stated this: yet another B, Afghan civilian, who after being sent back into A, the building, and being fully aware of being outnumbered, returns with a weapon, exclamation mark. Do you think that they ask the Bs to go in and bring any weapons they may have out, thereby setting the conditions for their execution? N2107's colleague replied, it's a good point. There appears to be a casual disregard for life. COIN, counter-insurgency principles, and credible reporting. Now, less than 48 hours after those emails were exchanged, Mr. Saifullah, who was then aged around 19, was at home with his family in his small village in Afghanistan. And in the early hours of the morning of 16th of February, the same SAS unit as the 14th of February conducted a night raid, Operation Tyburn, on the family's compound. They instructed everyone to go outside. Mr. Saifullah was held with the women and children, where he was searched, blindfolded and handcuffed for about an hour to an hour and a half. But it was during this time that he heard bursts of shots being fired. And when he left, when the SAS left, Mr. Saifullah found his father, Abdul Khalik, dead in one of the rooms with gunshot wounds to the head and the leg. Mr. Saifullah's cousin, Ahmed Shah, was found dead in a neighbouring family home with gunshot wounds to the neck. And several hours later, the bodies of Mr. Saifullah's two eldest brothers, Saddam and Atta Ullah, were found. They'd been shot in fields near the Saifullah family home. Now, official explanations for the deaths of Mr. Saifullah's father and cousins followed the same pattern that we've already seen in the small selection of raids that I've shown you, sir. The father and cousin were apparently directed to re-enter the two neighbouring family compounds. Mr. Khalik is said to have entered a room, reaches a curtain, even the hiding place is the same, and pulled out a hand grenade, which he attempted to throw at the British forces, but which did not detonate, and he was therefore, it was said, shot in self-defence. Mr. Shah was directed to re-enter the compound next door. He's said to have picked up an AK-47 from behind a table and was therefore also shot, it is said, in self-defence. And Mr. Hussain was apparently found hiding in a bush with a hand grenade, and Mr. Ullah was said to have been hiding under a blanket next to a mound of hay holding an AK-47, and both were allegedly shot in self-defence before they were able to deploy weapons they were said to be holding. Now, whether seen in isolation or whether seen in the context of all the other raids, you may in due course, sir, consider that these accounts are wholly implausible. 4 different men, each allegedly grabbing 4 different weapons held in 4 different places, which they then allegedly attempt to deploy against British forces in the face of overwhelming numbers and firepower, and in circumstances they would know that doing so would, as a matter of certainty, lead to immediate death. Each man is shot dead in the scintilla of time after they attempt to deploy the weapon, but before they succeed in doing so. No weapons, other than the ones that were allegedly found on the brink of being used, but none of which were actually used, were found in either compound. It's the same pattern. Following the incident, Mr. Saifullah and some of his relatives visited the provisional governor for Helmand in Lashkargah. And concerns were also raised by a reputable international organisation. And as we understand it, that is the same organisation referred to in those terms in other documents to which I will take you, and with whom British officers met to discuss this and a subsequent raid. Now, once again, the official account of the SAS raid was immediately disbelieved and derided by senior military officers. And so, again, this takes me back to what I mentioned right at the beginning of my outset. My critique of these raids, my questioning of plausibility, is not the construct of my legal team. It is a reflection and reportage of what hardened, experienced senior personnel were saying at the time. And so just hours after this incident, an email is sent by a British officer accorded the cipher N5459, who describes the incident as the latest massacre. Another officer, cipher 5460, expressed disbelief at the account of the incident provided by the soldiers involved, noting that it was the latest in a long line of identical, implausible accounts provided by the SAS subunit following such incidents. He said this: basically, for what must be the 10th time in the last 2 weeks, when they send a Bravo back into the building to open when they send the Bravo back into the building to open the curtains, he reappeared with an AK-47. Then, when they walked back into a different building with another detainee to open the curtains, he grabbed a grenade from behind a curtain and threw it at the call sign, that's the soldier. Fortunately, it didn't go off. This is the 8th time this has happened. And finally, they shot a guy who was hiding in a bush who had a grenade in his hands. You couldn't make it up. The obvious reading of that last comment, seen in the context of the email chain, the wider email chains, is that the author thought this was being made up. Entirely unbelievable. N2107, who, as I've just shown you, flatly rejected the SAS's accounts of the incidents on the 9th and the 14th of February, once again was quick to dismiss the official account of the incident. On the same day, he exchanged emails, this is N2107, with N2349, with a subject line which refers to the date of the incident, and with this heading, not enemies killed in action, but EJKS, a clear reference to extrajudicial killings, SAS. N2107 states bluntly, why are we the only ones who see this bollocks for what it is? And he added this, N1802, that's the Director of Special Forces, is keen to threaten people when, and there's a redaction, is breached, not that anything ever comes of it. And here he has a serious amount of questionable behaviour from the Special Forces that is gathering momentum. I'm unimpressed by 1786, that's the commander of SAS in Afghanistan, lack of control over this. So there's more. On the same day as the incident, yet another British officer, cipher N1791, sent an email which referred to concerns expressed by the Afghan partner unit that the incident had involved, and I quote, assassination of innocents on target, end quotes, and that the SAS soldiers responsible, and I quote, appeared to be beyond reproach, close quote, a state of affairs which a soldier described as, open quote, astonishing, close quote. N1791 explained that the commanding officer of the Afghan soldiers present at the incident had reported that 2 men were shot trying to run away, and that the other 2 men were assassinated on target after they had already been detained and searched. The APU have apparently complained to the commanding officer that no one was firing at the SAS, but they were shot anyway. He sees this as confirmation that innocents were killed. Officers at the Special Forces headquarters in the United Kingdom also expressed deep scepticism about the official SAS account of the operation. On the day of the incident, the Chief of Staff at UK headquarters of Special Forces, basically the second in command as we understand it of UK Special Forces, forwarded a OPSUM, that's the operational summary, for Objective Tyburn to N2108, who we understand to be the most senior lawyer at Special Forces headquarters. And he stated this, 4 EKIA, 2 weapons recovered, worth a look, question mark. The lawyer replied in an email you can see on the screen and stated, I share, and this SAS UK headquarters, concerns about the recent spate of high EKA and have noted the emerging TTP, that's Taliban technique or procedure, of supposedly hiding grenades behind curtains. He went on to state, I get the sense that we are that the way we are writing these up will not bear scrutiny in years to come. And he referred to the inevitable public inquiries that were followed. Words written in 2011 that have sadly proved prescient. So knowledge of the allegations that Mr. Saifullah's relatives were killed unlawfully and were thus widespread amongst upper echelons of special forces. Indeed, a review of emails by Operation Northmore, subsequently in 2017, established that there were 18 people who were not directly on the operation, but appeared to have had knowledge of the accusations of misconduct. I'm going to return to that later, sir, when we look at the judicial review proceedings and the question of continuing cover-up by the MOD. Now, despite the extent of knowledge of those accusations and the widespread disbelief of the SAS's account of Operation Tyburn and the other incidents that had preceded it, and despite what I have shown you were the clear expressions of strong suspicions by multiple senior forces personnel that the men killed in these incidents had been potentially murdered, no action was taken to meaningfully investigate these matters or refer them to the RMP, or to prevent the perpetration of further episodes. And I'm going to return again to that in more detail shortly. As a result of the failure to take any action, the behaviour of the subunit, as we will see, went unchecked, and the incident in which Mr. Saifullah's relatives were killed was followed by multiple further incidents which bear very many of the same hallmarks identified by senior personnel in the special forces themselves as being highly suspicious. I'm going to turn to the next incident in time, sir, which is the 12th of March 2011. So it's about a month after Mr. Saifullah's relatives were killed. 8 of Mr. Shafiq Ullah's relatives, including his father, were killed by the same SAS subunit. Mr. Shafiq Ullah was 9 years old at the date of this incident. It involved a raid on several separate but nearby compounds in the village of Khan Ano in Helmand. And in the early hours of the morning, when the soldiers had departed, Mr. Shafiq Ullah's family discovered that across those compounds, 8 of their male relatives had been killed. Now, the features of this incident, even when considered in isolation, never mind as part of a pattern, but even in isolation, are extremely suspicious. Firstly, most of Mr. Shafiq Ullah's deceased relatives were found in a room where they would have been going to sleep, and they appear to have been killed while either lying or sitting down. Mr. Shafiq Ullah's uncle, Zabi Ullah, was found dead under duvets and bedding. Secondly, this is another case where there was a discrepancy between the numbers of deaths and the weapons. 8 people were killed, but even on the official account, only 6 weapons were said to have been recovered from the scene. Thirdly, the official account of the incident may be thought, on analysis, to defy credibility. First, it suggested that 3 men were killed after they'd escaped from the custody and control of the SAS unit and managed to seize, but not successfully deploy, a weapon against those soldiers despite the impossible odds. Second, they suggest that one unarmed man was killed after he attempted again, against impossible odds, to pick up an assault rifle that had been dropped in front of him by another man who'd just been shot. Third, they suggest that another man was then shot dead after attempting to deploy a weapon against the SAS, despite having seen the previous 4 men being shot in similar circumstances. Then they suggest that 2 more men were shot dead, one after trying and failing to shoot the SAS, the other after trying and failing to throw a grenade at them. In both cases, after 5 men had just been shot in materially identical circumstances. This is an account of simultaneously suicidal behaviour on the part of the 7 dead Afghans, and it may be thought to be inherently implausible. If it were true, it would of course represent a rather unlikely failure of the soldiering by the SAS on the ground. Now, again, the critique of this raid, even seen in isolation, is not the construct of lawyers sitting in the comfort of a courtroom, absent the cruel and brutal reality of battle. Again, the critique, the disbelief, is recorded by other soldiers within the SAS. And again here, immediately after the incident, the official account, is met with scepticism within Special Forces. 2 days after the incident, N2107 sends an email which attached the operational summary and observed with what we would say is grim irony, back to the good old tactics. N1791 responded, "However you look at it, that is a lot of EKIA for the number of weapons reported. I suspect they were wearing green jackets." N2107 in turn replied with a message which compared a comparison with another operational theatre and stated again, it appears with grim sarcasm, "In Afghanistan, the various individuals are more sporting and appear keen to engage in quick draw challenge once the unit has made entry into the house." Around 3 weeks later, another British officer sent an email which attached the same operational summary and stated, "In my personal opinion, it does not read well." Following this incident, people from the village made complaints to the regional Afghan authorities, and the same reputable international organisation, which had raised concerns about Objective Tyburn, also raised concerns about this night raid. And a meeting took place in May 2011 between UK armed forces and that international organisation to discuss those concerns. So I should just interpose here. I'm only going to refer to it as an international organisation, but so that it's clear, that's because some, and there are many, international organisations that in order to fulfil their work need to know that they can do so and have conversations that are kept secret, and we entirely understand that. And nothing, I will say, will identify any organisation, but it is an international reputable organisation. So the meeting took place, and what we're told is a contemporaneous UK Armed Forces note of that meeting records the organisation's concern about the SAS's apparent conduct on night raids. The documents, and I quote, refers to the night raids, which involve sending, with their consent, an occupant back into the building to assist with clearance, could allow the male to be deliberately directed, and directed is put in parenthesis, to pick up a weapon and then to be engaged in a manufactured self-defence scenario. So in other words, what's being raised here are concerns about a premeditated murder dressed up as self-defence. So this reputable international organisation has thus independently reached the same conclusion as N2107, reflected in the email of the 14th of February, which I referred to a few moments ago, in which he asked, do you think they ask the Bravos to go in and bring weapons they may have out, thereby setting the conditions for their execution? So, through 2 different routes, 2 different analyses from individuals and organisations who you may think might bring specialist knowledge, 2 identical conclusions, or at least very grave concerns. Now, a subsequent meeting between Special Forces representatives and that reputable international organisation took place in July 2011. And at that meeting, the organisation reiterated its concerns about the use of persons under Special Forces control for military operations, putting them at risk of harm by using them for search and clearance operations. It also referred to the SAS's high kill stats and the perception that they might have a high rate of kill on capture/kill missions. Between concerns raised by Afghan armed forces and political figures, British soldiers both in Afghanistan and back at headquarters in the United Kingdom and this international organisation, there was, it appears, a groundswell of concern in 2011 about the conduct of the SAS. But little, if anything, was done to prevent such conduct continuing. Indeed, although they're not represented as core participants in this inquiry, we know that at least 5 more suspected incidents of extrajudicial killing took place in the course of 2011, including on the 18th of March, in which 4 people were killed, the 2nd of April, on which 2 people were killed. In addition, sir, there's this. On the 20th of June 2011, 8 individuals were killed in an SAS raid, and a member of the Afghan unit present on that operation alleged that at least one of those individuals, who he described as an unarmed elderly male, was, in his words, unlawfully killed by the SAS subunit. On the 26th of July 2011, Special Forces engaged in an operation codenamed Operation Y, during which an individual was shot in the arm and then detained. Now, on this occasion, a decision was taken, and we can see the document, to use the detainee to do a call out from the tree line where the previous gunfire was coming from. I think that must be gunfire. The detainee was wounded and clearly reluctant to engage in the process. The detainee was with 3 members of Special Forces. There was further gunfire, and they dropped like a stone. Now, the most senior lawyer in the SAS headquarters, cipher N2108, observed that the incident involved a failure to protect the detainee from military operations and had increased the risk to military operations. It was an incident, he said, demonstrated a failure to get the message through. Next, on the 12th of December 2011, an SAS subunit was involved in an incident in which 4 individuals were killed. A short while later, N2108 forwarded the official account of the incident to others in the SAS and noted this. This is a 4 EKIE with 1 pistol recovered scenario. He indicated that he was forwarding the operation summary because he knew how the top corridor views some of these incidents. He added, "It's not for me to doubt the word of the subunit, but we may just need to keep a close eye on this." So the same conduct, though, sir, continues to occur. And I'm going to take you along the timeline to the next incident, which is a raid that occurred on the 6th and 7th of August 2012. And this is a night raid by the SAS, which took place across 2 neighbouring compounds in the village of Shesh Abba in the Nimruz province of southern Afghanistan, a raid which affects 3 of the inquiry's core participants. So I'm back, sir, on one of the 7 incidents for the families that I represent. Now, in the early hours of that morning, the SAS raided the compound of Mr. Aziz's family. His brother, Uzbak Zai, and his sister, Ms. Halim, were sleeping outside in the courtyard with their 2 pre-children age, Imran and Bilal, and that's because it was due to the heat. The SAS soldiers shot all 4 of them. They killed the parents, and they severely wounded the children. When Mr. Aziz returned to the compound after hearing there had been an incident, he was horrified, as you would understand, to find the two bodies of his brother and his sister-in-law, and to find that the children were missing. It was later discovered that they'd been medically evacuated to military facilities for urgent treatment. Now, this is another highly suspicious incident where it is understood that the deceased and their young children were shot at while sleeping in their beds. Before I turn to some of that, I want to play you, if I may, a short video from Mr. Aziz and to show you photographs of the two children.
Bismillah ar-Rahman ar-Rahim. I'm Mansour Aziz. Bismillah ar-Rahman ar-Rahim. من منصور یزدی هستم از ولایت نیمروز ولسوالی خاشرود قریه شیش آبا. سنم تقریبا 30 سال است. در سال 2012 تقریبا بالای خانه ما چاپه زده شد. خارجی‌ها بالای خانه ما چاپه زدند. برادر و برادرزنم را کشتند و دو تا فرزندش را به شدت زخمی کردند که طرف راستم عمران است و طرف چپم بلال است. این دوتا را به شدت زخمی کردند و اینا در یک خانه فقیرانه بزرگ شدند و هنوز از همون حادثه که بالای خانه ما پیش شد نگران هستند و افسرده هستند که این کار چرا با ما شد، به چه دلیل شد. حالا ما میخوایم حقیقت را بفهمیم، حقیقت چی بود که بالای خانه ما چاپه زده شد و ما از دادگاه عالی میخوایم به داد اینا برسد. السلام علیکم.
I think we can also show you photographs of the children. So, as well as shooting the two children and killing their parents, once the SAS unit had departed, Mr. Lal, another bereaved family member represented before you, had the horror of discovering that two of his sons, Mohammed Wali and Mohammed Juma, who were asleep in a separate area of the compound, had been shot dead, apparently at close range. Now, official reports relating to this incident highlight just how suspicious the circumstances of the killing were. The only weapon found, or alleged to have been found, during the raid was a single grenade. This is yet another example, therefore, of a large discrepancy between the number of people killed and the number of weapons apparently found. So you may reflect that it is particularly surprising that this case was not referred to the Royal Military Police in circumstances in which young children were seriously injured, and where it was obvious that civilians were shot in bed. And when the RMP eventually found out about it, they also failed to take any steps to investigate the circumstances of the deaths. The document on the screen is an extract from an RMP investigator's workbook, which records certain information about the incident. It states that an officer, N1783, told the RMP about two separate incidents during his last week in post, which due to the circumstances upset the Afghan and was reported up the chain of command to headquarters and subsequently had the intention of both President Karzai and General Allen. The workbook goes on to explain the second incident involved a subunit and the Afghans. They deployed into a compound during a night operation. During the operation, 4 or 5 Afghans were killed and 2 children were injured. The children were subsequently evacuated for medical treatment. Only 1 grenade was recovered during the operation. N1793 recalled that there was lengthy email correspondence between Command ISAF and UK headquarters in relation to Incident 2 above. It seemed unusual, disproportionate that so many individuals were killed with little evidence of the scale of the threat, i.e. 1 grenade. He further stated that he was surprised by the response of headquarters, which was defensive in posture. So I'm going to move to the next incident and the final incident of the 7 in the timeline, involving the relatives of the core participant families. And this is one that took place on the 18th of October 2012. It formed the basis of the other claim for judicial review that led to this inquiry brought by Akhtar and Shapia Norzai. This is a case in which 4 of their family members, 3 of whom were children, were killed by the SAS in another night raid. And we have photos of them on the screen. After the soldiers left, it was Akhtar who found Fazal, who's the 18-year-old, and the 3 children dead. Naik, Mohammed, Ahmed, shot in the neck from below. They were lying next to each other, and the walls were covered with bullet holes. So we're going to ask you to consider, when you examine this case, both in isolation and in context, that whether the explanations for those deaths are credible, whether they are consistent, both with themselves, both with common sense, and, as I'm going to develop a little later on, with the forensics. Initial reports, official reports, were plainly false. They recorded that the children opened fire and that no fatal shots were fired by the SAS unit. Instead, the initial reports seek to blame the Afghan partners. But the British soldiers involved later admitted that this narrative was indeed false, and provided, and have never provided, any explanation for the discrepancy between the initial account and what they later said when they realised the matter was being properly investigated. I'm going to return in some more detail, sir, if I may, to this raid when I describe the subsequent RMP investigation into it, also codenamed Sestro. Before I leave the facts of the individual raids, sir, can I make a general observation about the contemporaneous documents, such as the operation summaries that we've seen over the last few days, and in which you will no doubt have many more? In circumstances in which you are blessed with an inquiry team staffed by the most highly experienced criminal practitioners, it hardly bears stating that documents of this nature need to be carefully scrutinised and the contents not necessarily taken at face value. That's a statement, I'd suggest, of the blindingly obvious in these circumstances. You will have seen, though, that experience in Australia bears out the obvious. What does bear articulating at this stage is that particular care may need to be given to the intelligence assessments recorded on those documents. And this may become particularly relevant when you take evidence of a generic nature about the situation pertaining in Afghanistan during the relevant period. And you, sir, we would suggest, may want to understand and receive evidence about the reliability of intelligence of this nature generally. So I'm addressing you now, not, sir, on the discrete issue as to whether or not the intelligence entries were accurate, reflected what was known by those conducting the raid per se. You no doubt will consider that. But this is a much more general point about the reliability of intelligence of this nature at this time. For example, what was the quality of intelligence assessment, particularly with regard to low and mid-level targets? And also, and it may be pertinent, was there any perception of a pressure at this time to provide intelligence in order to enable raids? All the more important, sir, if you're looking and considering the context of a rather gruesome competition between subunits and partner units. Again, sir, you will know that this is something that has been considered and upon which evidence was received by Judge Advocate Brereton in Australia. So that is all I wish to say about the 7 raids and the context in which they fall. Would that be a convenient moment for a break?
Indeed it would, Mr. Hermer. Thank you. We'll break now, please, until 20 to 12. Thank you. Yes, Mr. Hermer.
Thank you, sir. Before I turn directly to part two, looking at the evidence capable of supporting the allegations of unlawful killing, can I just touch for a moment on what we see as the four overarching core issues for your inquiry to consider and reach conclusions upon. The first of which is the extent to which there existed at the relevant time widespread pattern of extrajudicial killings by the SAS in Afghanistan. Second, the extent to which those deaths were then covered up by those with knowledge of the suspicious circumstances, in particular the chain of command and other arms of the British military and relevant civil service. Third, the extent to which the RMP adequately investigated those allegations of both extrajudicial killing and of cover-up. And then fourthly, the ways in which the questions of system, management, institutional culture contributed to any systemic failures that you identify, and what lessons, if any, can be learned for the future. And in our respectful submission, sir, when you're investigating those issues, it's essential that the inquiry does not only focus on the individuals who were on the ground during the raids, on the evidence that we have seen thus far placed in the public domain. Responsibility for wrongdoing, if found, both in terms of a failure to prevent it and in terms of cover-up, reaches far higher up the chain of command. Indeed, it reaches the very top, or is capable of reaching the very top, of the UK Special Forces and the upper echelons of the Ministry of Defence. Documents disclosed in the judicial review proceedings indicate that successive directors of the Special Forces, who we know in the public domain to have been Lieutenant Colonel Jonathan Jacko Page and Sir Mark Carlson Smith, had knowledge of serious suspected wrongdoing by the SAS, but failed to ensure that it was passed to the RMP, and failed to take any steps to investigate that wrongdoing and prevent its reoccurrence. Not only that, there is evidence capable of demonstrating a concerted attempt amongst senior officers in the UK higher headquarters of Special Forces to deliberately ensure that such information was withheld from the RMP. Troublingly, those efforts to leave the RMP in the dark also involved at least one very senior Special Forces lawyer, someone who was well versed in the terms of the Armed Forces Act and who was well aware of the legal duty to refer any suspected criminality to the RMP. And when the RMP finally did learn of the suspicious incidents and began an investigation, staff at Special Forces higher headquarters, on the evidence it would appear, sought to stymie the progress of that investigation by obstructing access to important evidence. Who knew about that obstruction? Who sanctioned it? Who carried it out? And what motivated it? Are all, we would respectfully submit, important questions for you and your inquiry, sir. The need for rigorous scrutiny of the conduct of senior Special Forces commander is reinforced by evidence that the RMP investigators were placed, and I quote, under political pressure, end quote, not to investigate command-level responsibility, i.e. the responsibility of senior officers. Indeed, it appears on the evidence, certainly capable of being suggested on the evidence, that the investigators yielded to that pressure, since they failed to interview the director of Special Forces and the in-theatre commanding officer of the SAS, responsible for scores of suspicious killings. Never interviewed. The documents that we have seen also seem to demonstrate that the existence of serious suspicion of extrajudicial killings were widely known within the highest levels of government, at the top of the Ministry of Defence and even in 10 Downing Street. On the 19th of February 2016, for example, the Chief of Staff and the Parliamentary Private Secretary to the Defence Secretary, Graham Biggar, wrote to the Director General of the Prime Minister's Office, then Simon Case, copying in the Cabinet Secretary and the Attorney General, explaining that information from highly credible armed forces sources, the RMP are now investigating a number of cases of suspected murder of Afghans by members of UK Special Forces. The letter was drafted by the head of the Ministry of Defence, Director of Judicial Engagement Policies, Peter Ryan, who in the same year also described concerns about what he called, open quote, political and reputational damage, close quote, arising from the course that Operation Northmoor might take. On the 1st of September 2016, the Provost Marshal of the Army, David Neal, met with the Ministry of Defence's Permanent Secretary, who stated that he was, open quote, troubled by a culture in, close quote, the UK Special Forces, and described a widespread view amongst government officials of this, that they had gone too far and that there was an increasing loss of sympathy for UK Special Forces in Number 10 and the Cabinet Office, and some felt that it was time for it to have its wings clipped. There was no shortage of detractors, and that in particular the Cabinet Secretary, Sir Jeremy Hayward, the late Sir Jeremy, was a detractor. Knowledge of suspected wrongdoing by Special Forces was thus apparently widespread at the very top of government. And the inquiry will need to investigate what, if anything, was done in response, and in particular whether, as the documents we have seen are capable of suggesting, the RMP's investigation may have been tainted by political pressure and improper interference. Can I turn then, sir, to the unlawful killings? And I'm going to divide this up by firstly just standing back at the suspicious incidents and deaths over the relevant period. I'm going to turn to the concerns raised by the Afghan partner units, and then I'm going to identify I've already touched upon it to some degree, the suspicions and knowledge as to what was going on the ground amongst the Special Forces chain of command. Although most of my submissions this morning focused upon the 7 raids that are relevant to the relatives of those that I represent, we're aware, and I've already touched upon some, of other similar instances during the period covered by the inquiry's term of reference. The high rate of fatalities during those incidents prompted the creation of what was called an incident tracker in September 2010, months before any of the incidents that I've outlined, to keep a track of all the killings by the SAS in Afghanistan. The evidence that we have seen so far indicates that there were at least 30 incidents in which Special Forces were involved in night raids with an inexplicably high Afghan casualty rate, and that at least 80 people were killed during these incidents. The extent of the fatalities is illustrated by the fact that a single member of the SAS subunit admitted to personally killing 35 people on a 6-month tour. Another squadron deployed immediately beforehand had an even higher rate of fatalities, whereas the subunit that we've seen ciphered as 1A killed on average 1.5 individuals per operation. Subunit 1C killed an average of 2.7 individuals, an 80% higher rate of deaths. Now again, sir, I want to stress that very often, very brave soldiers are required to go into the field and kill people. And the mere fact that there may be a high casualty number cannot of itself be said to reveal illegality. Sometimes it may just simply reveal extraordinary bravery. But the concerns as to the rates here are those expressed within the military. This is not lawyers or human rights groups standing back and looking and simply saying the numbers seem high. It's the concerns of the military. Indeed, as was highlighted by the reputable international organisation that I referred to earlier, the kill rate of these units during this period was unprecedented. And when examined, some in isolation but all together, in our submission, you may well come to the conclusion that there was no credible justification for these multiple deaths across most of these raids. You will no doubt look carefully at the explanations that were given at the time to assess whether on their face they are credible. You will no doubt look carefully at the issue of the number of weapons that were retrieved. And you may, sir, take the same route as was taken in Australia that had great probative value of your own expert analysis with assistance of experts on some of the materials that were recovered insofar as they exist still. Now, these suspicious incidents stretch from, and sir, you'll appreciate that all my submissions are based on information in the public domain, or certainly, that, if not in the public domain, disclosed in the judicial review proceedings, and the inquiry is going to have far more. But from our analysis, the incidents stretch from at least the middle of 2010 until at least the middle of 2013. On the 10th of May 2013, for example, so right at the end of the period, an individual was shot by a member of the SAS with the cipher 1164 in circumstances in which the RMP said gave concern to possible contravention of the rules of engagement and the law of armed conflict. And it bears noting that N1164 was a member of the subunit involved in Operation Tyburn, in which 4 of Mr. Saifullah's relatives were killed. So that's the numbers, that's the pattern. If I can then turn to the concerns that were being raised by the Afghan partner units, so these are military units conducting raids together with the SAS. Members of those partner units repeatedly, it appears in the documents, repeatedly raised concerns about the conduct of the SAS during the raids, and in some cases refused to continue to serve with those subunits because of those concerns. In April 2011, a British soldier who is ciphered as N1788 sent an email that recorded this, open quote, "Within the current squadron," that's the subunit 1 tenure, "the APU have refused to soldier on 3 occasions, December 10, February 11 and April 11, close quote. In addition, they refused to soldier on various, open quote, other times in the previous squadron's tenure, i.e. before the 20th of November 2010, close quote. At the same time, the Director of Special Forces referred to a, open quote, sense among members of the Afghan partner unit that squadrons of subunit 1, SAS, can be overly kinetic during the clearance phase of, would appear to be detention operations. In several instances, the APU has refused to accompany the subunit on any further operations, close quote. Overly kinetic, we would submit, may well be a euphemism for unnecessary and unjustified use of lethal weapons. It would explain the reaction of our partners. As I've already observed, sir, in relation to Operation Tyburn, that's the raid that killed Mr. Saifullah's family members, the APU alleged that there had been an assassination of innocents. and refused to continue to serve alongside Subunit 1. But according to an email from April 2011, this was not even, an open quote, the two operations that have caused the most angst within the APU, close quote. Those operations were instead said to be an Operation Turton, or the 15th of February 2011, and an operation of the 4th of April 2011, the name of which we haven't been provided with. There are no core family participants, sir, in relation to either of those two incidents, but they will nevertheless be incidents that the inquiry will no doubt wish to investigate very carefully indeed. What caused the concerns of the APU in respect of those incidents? And what was it about those incidents that was of more concern to the APU than even Operation Tyburn? And you will recall, sir, and you will see from the evidence, and time doesn't permit me to take you to it all, just the enormous strength of feeling by the members of the APU arising out of Tyburn. And if these two operations created greater emotions amongst the Afghan partners, then it calls out for careful scrutiny. The APU's concerns and refusals to serve alongside United Kingdom Special Forces were not confined to Subunit 1. There was what was described as a strange relationship between Subunit 3 and their Afghan counterparts, due, it was said, to the unhappy way in which Subunit 3 did business. The concerns were so great that the APU refused to soldier with Subunit 3, and on at least two occasions it was said that the conduct of Subunit 3, that it upset the Afghans so much that it was reported up the chain to their command and subsequently had the attention of both President Karzai and General Allen. And we are told from the documents that the commanding officer of the Afghan unit was unhappy with SU-3 and complained about them frequently. And these concerns reflect, you may consider, the scale of the potential wrongdoing, which seemingly extends beyond Subunit 1. And that's our Afghan partners. Can I turn next to the suspicions and knowledge amongst the Special Forces chain of command? I've already identified that the unusual number of deaths caused during the raids did not go unnoticed by the Special Forces chain of command. Far from it, sir. There were numerous contemporaneous expressions of concern made by serving British soldiers and their commanding officers, by members of the Afghan forces, as we have seen, and by senior Afghan government officials, as I've just alluded to, as well as you have seen, an international organisation of repute. And these concerns were brought to the attention of officers high in the chain of command, and they include a Major General in the UK Special Forces headquarters in the United Kingdom, a Lieutenant Colonel who was the in-theatre commanding officer of the SAS, the Chief of Staff and Assistant Chief of Staff of higher headquarters in the United Kingdom, the SAS's most senior lawyer and the most senior political advisor, and two successive directors, as I've already identified, directors of Special Forces. However, from 2010 to 2013, none of these individuals took any steps to report the suspicions to the Royal Military Police, despite being under a statutory obligation to do so pursuant to Section 113 of the Armed Forces Act of 2006, a clear and obvious legal obligation that mirrors the professional and moral obligation to report suspected crimes. And as far as we are aware, only one of the core participant incidents, one of the 7, that affecting the Norzai family in November 2012, was eventually referred to service police, and that was due to the involvement of UK lawyers, and the years preceding that referral and the subsequent establishment of Northmoor were instead, we would submit, capable of being characterised as by orchestrated efforts of senior officers to prevent the RMP from finding out about the incidents and launching an investigation. Now, the paper trail, sir, of concerns being raised early in the period of which this inquiry is concerned is extensive. Internal SAS emails in January 2011, some of which we have seen, show officers questioning accounts of, open quote, life-threatening movement by people without weapons, close quote, and noting that instances of unarmed Afghans being killed were higher than normal. I showed you a few minutes ago that throughout early 2011 there were emails expressing incredulity about the official account of SAS night raids in which Afghans were killed. And you may consider that the language of those emails is stark, striking and illuminating. SAS accounts of killings were described as quite incredible. We don't believe this. You couldn't make it up. We see the bollocks for what it is. The way we are writing these up will not bear scrutiny in years to come, etc., etc. Not only do the emails which I've referred dismiss the official SAS account of those operations, they are replete, as you would have seen, with references to suspected extrajudicial killings by the SAS. They refer to EJK, extrajudicial killings, not enemies killed in combat. They refer to the latest massacre, to the assassination of innocents on target, to innocents were killed, to setting the conditions for their execution, to a manufactured self-defence scenario, to a casual disregard to life, to a serious amount of questionable behaviour that is gathering momentum, and to murder and the SAS have oft been regular bedfellows. These, sir, are the words of the SAS. There is much more. The email trails indicate that at least 12 serving officers in the Special Forces headquarters in the United Kingdom and Afghanistan were aware of or themselves had serious concerns about the number of deaths in raids in February 2011, and that by March 2011 there were rumours of SAS units adopting a policy to kill all fighting-aged males, open quote, irrespective of whether they posed a threat or not, close quote. This would, of course, constitute, if true, a clear and grave breach of domestic and international law and of the law of armed conflict. Yet, as the inquiry's term of reference and the narrative of the individual instance I've already given make plain, little was done to interrupt such policy, to ascertain whether it was true, to report in accordance with law, and similar incidents, therefore, you may find, continued unabated until at least the middle of 2013. So you can get a flavour of the nature and extent of the concerns and suspicion from documents produced and emails sent in April 2011. On the 4th of April 2011, for example, the Assistant Chief of Staff Policy at SAS Higher Headquarters in the United Kingdom, referred to by the cipher N1803, sent an email to various individuals at those headquarters attaching an operational summary, OPSUM, for Operation 10, which is another night raid with no core participant involvement. He noted that this was another example of the asked B to go back in to help clear and end up killing him routine. In a statement, he said he'd had conversations with N1788 and N1466, two senior Special Forces officers, regarding my concerns with the TTP, and that he'd also spoken to N2108, the SAS's senior lawyer, about my concerns regarding the TPP and the concern that it might fall outside the remit of the rules of engagement. The following day, N1785, that's the commanding officer of one of the implicated subunits in Afghanistan, sent a communication to the director of Special Forces. The communication was headed Allegations of EJK by, we assume it's the SAS, subunit. It stated this: I have been aware of rumours within, we assume is the SAS, that subunits have been conducting summary executions of supposed Taliban affiliates on target in Afghanistan. I have now been given more information of a nature that makes me seriously concerned for the reputation, again we assume, of the SAS. One of my team, an officer, has been told by an individual that there is in effect an unofficial policy amongst the we assume the subunits to kill, wherever possible, fighting-aged males on target, regardless of the immediate threat they pose to our troops. In some instances, this has involved the deliberate killing of individuals after they have been restrained by the subunit, and the subsequent fabrication of evidence to suggest a lawful killing in self-defence. What I have been told does not amount to anything substantial as evidence, but to my sense it is more than just what had been, until recently, vacuous rumour. But if our armed forces individuals are conducting EJKs, then the implications are clearly stark. Notwithstanding this, I feel most strongly that thorough and appropriate investigation is warranted. For information, I've asked the officer concerned if he would provide a statement, if asked to do so, as part of a formal investigation. He would. 2 days later, on the 7th of April 2011, a very senior officer at the SAS headquarters, N1466, sent an email to the director of Special Forces, which described concern amongst some officers of this, that there was possibly a deliberate policy amongst, we assume the subunits, to engage and kill fighting-age males on target, even when they did not pose a threat. These concerns, sir, about the potential existence of a policy to murder, were said to be based not simply on discussions with others within the military, but separate concerns about high levels of fatalities reported on the particular unit's current tour compared to others. N1466 explained to N1785 that had been approached by some members, I beg your pardon, I'm going to start that again. He explained that N1785, this is N1466, had been approached by some of his men who recounted separate conversations with, we assume, Special Forces members of the SAS subunit, of the armed forces, in which such suggestions had been made. Now, N1785 reported that he was sure that they are accurately reporting what they are hearing from colleagues. N1466 stated that he found the position very disturbing and that, he said, my instinct is this merits deeper investigation, hopefully to put minds at rest, including the Afghan partner units, and to make a clearer statement to the UK armed forces, or at worst, to put stop to criminal behaviour. On the same day, N1788 sent an email regarding the stats of the subunit, which contained an analysis of night raid statistics for the 18-week period since the 1st of December 2010. The email reported this: 11 separate incidents spanning 9 discrete operations in which the TTP of sending an Afghan male back into a building to assist with clearing it resulted in the same Bravo Afghan being killed, in brackets, reaching for a weapon, etc., from the operational summary. 8 weeks when the number of EKIA, enemy killed in action, exceeded the number of detainees taken, and 6 separate incidents in which the number of EKIA exceeded the number of weapons officially found on target. He added that if one were not to include grenades as a weapon, then the number of such incidents is around 11. In addition to these communications between various senior Special Forces personnel, on the 6th of April 2011, what was described as a controlled access security compartment, which came to be known as Compartment A, was created. And the purpose of its creation was described thus: for protecting contemporaneous anecdotal information that members of the same UK Forces subunit had carried out extrajudicial killings while on operations in Afghanistan during the same time period as Operation Tyburn. Now, according to the contemporaneous compartment definition, what was put in the compartment contained anecdotal evidence suggesting extrajudicial killings had been carried out by members of the subunit in Afghanistan, has been recounted by armed forces ranks who have served on what we think is the subunit to an officer. The information deemed to be protected then in Compartment A, sir, included A, the existence of EJK allegations, B, details of those allegations, C, the identification of ranks, 4, the identity of the relevant officer, and, I beg your pardon, E, the progress of the investigation. And the purpose of Compartment A was said to provide an additional level of control over the handling and the briefing of more sensitive aspects of this matter. This is because, it was said, dissemination of the information protected by this compartment could cause severe damage to the reputation of UK armed forces, we assume, and could prejudice further investigation and could disrupt current operations. One document that we know was placed in Compartment A, in a safe, which is a safe, is a memo, rather a written statement, that N1779 was directed to produce after raising concerns about information of which he had been told. And his statement is dated the 24th of March of 2011. And it says, amongst other things, this: during conversations with a soldier, we assume from a subunit, he stated that it was standard procedure to deploy regularly to hit low and medium value targets in the Helmand area. During these operations, it was said that all fighting-age males are killed on target, regardless of the threat they posed. This included those not holding weapons. It was also indicated that fighting-age males were being executed on target inside compounds using a variety of methods after they had been restrained. In one case, it was mentioned that a pillow was put over the head of an individual being killed with a pistol. It was implied that photos would be taken of the deceased alongside weapons that the fighting-age male, in quotes, may not have had in their possession when they were killed. N1785 expressly drew this information to the attention of the Director of Special Forces, both by letter and by discussing it with him personally. N1785 described how the Director was, I quote, unhappy about the nature of the information, close quote, but he appears, notwithstanding that, to have taken, this is the Director, no action to investigate or refer these serious allegations to the RMP. This information was buried in a safe for a number of years. And the inquiry, no doubt, will wish to examine with care whether this was the proper course in respect of information of such obvious gravity and concern. Raising allegations of effectively mass murder, potentially, and grave breaches of the Geneva Convention. At least 6 senior Special Forces personnel had access to Compartment A, but the existence of this secure repository of evidence, raising the potential of a pattern of extrajudicial killings, was not disclosed to the Royal Military Police until 4 years later. The inquiry may very well wish to examine why none of those officers considered it necessary to refer any of the information in Compartment A to the Royal Military Police. Could I turn, as I said I would, sir, to the question of dropped weapons? Alongside what I've just described as the sequestering of information relating to allegations of extrajudicial killing in Compartment A, and what you would have seen as suggestions of manufactured evidence of self-defence, there is also evidence capable of suggesting that special forces deliberately used dropped weapons to conceal the fact that civilians had been murdered. A member of the Afghan partner unit who served alongside Subunit 1 informed Operation Northmoor that British soldiers would, open quote, carry an old Kalashnikov rifle with them. They would engage and kill people, place a weapon next to his body and photograph it in situ, close quote. And that is consistent with the evidence of a British officer, Cipher N5678, who attended numerous post-operation meetings and debriefs with UK Special Forces in late 2009, and who strongly suspected that weapons had been planted by Special Forces at the scenes of killings which took place around that time. 5678 said this: often these photographs images would show an individual who had been killed at the scene holding an AK variant rifle. Upon looking at these images, I became suspicious, as on numerous occasions it would appear that the same rifle would be in more than one photo with an EKIA. When this was questioned during the meeting, UK Armed Forces 3 would state that the insurgents had picked up the same weapon and were therefore engaged and killed. I noticed these weapons as being the same, as after dealing with numerous AKs, I know that no two AK rifles are the same. For example, some would be decorated by insurgents. Others would have different coloured barrels and various marks. I found this very suspicious. In other cases, there would be images of more than one EKA with a weapon, but only one weapon would come back for exploitation. And so, as you all know, the allegation of dropped weapons has some resonance with the investigation into strikingly similar allegations of misconduct levelled against the Australian Special Forces, considered by Advocate Judge Brereton, who found in his report multiple instances where there was credible evidence of extrajudicial killing by Australian troops. And the matter is now being considered by a special prosecutor in Australia. And as you all know, the Brereton inquiry, which identified 23 separate operations with credible evidence, found amongst others things this, and I just quote from a part of the report: credible evidence that members of the Special Operations Task Force carried throwdowns. This is a finding by Advocate Judge Brereton. Foreign weapons or equipment, typically though not invariably easily concealable, such as pistols, small handheld radios, weapon magazines and grenades, to be placed with the bodies of, open quote, enemies killed in action, close quote, for the purposes of site exploitation photography, in order to portray that the person killed had been carrying out the weapon or other military equipment when engaged and was a legitimate target. The practice probably originated, Judge Brereton said, for the less egregious, though still dishonest purpose of avoiding scrutiny, where a person who was legitimately engaged turned out not to be armed, but it involved to be used for the purpose of concealing deliberate unlawful killings. Now, we've no doubt that this is a matter that the inquiry will wish to carefully consider when examining all the relevant detention operations and looking at all the evidence in the round. It may or may not throw light on findings that you make, but it may be thought to be particularly apposite to do so, not least in light of some of the evidence that is capable of suggesting that UK special forces were in some form of ghoulish competition with special forces of partner nations for the most number of kills. I want to return, if I may, to the failure to report suspected extrajudicial killings to the Royal Military Police. So despite the plethora of suspicious features of all the instances to which I've referred, none with the exception of the Norzai incident, which was referred following the engagement of United Kingdom lawyers on behalf of the family, was referred to the RMP for formal investigation. Now that, sir, we would suggest, was no accident or oversight. Documents disclosed in the Saifullah Judicial Review demonstrate, or are capable of demonstrating, that deliberate and active efforts were made by multiple Special Forces personnel to avert any formal investigation of suspicious incidents. These efforts to withhold the incidents from RMP scrutiny involve the Special Forces, or appear to involve the Special Forces' most senior lawyer and a commanding officer at the Special Forces headquarters in the United Kingdom. Email chains in which they were involved contain discussions, and we've seen these in Mr. Glasgow's opening before you, sir. They contain discussions as to how to, what is described as, nip allegations in the bud before what is said they are fed into either the national or ISAF chain of commands in Kabul, attracting lots of scrutiny. The emails express concern that if this particular complaint gets elevated to a higher level, then we will lose control of it, and our political masters could knee-jerk and apply pressure for a SIB, that Special Investigations Branch of the RMP, investigation. So instead, and despite the seriousness of the allegations that were known to these individuals, their, and I use their words, aspiration was, and again I use their words, to deal with the complaint informally at the lowest level without it being raised unnecessarily at a higher level. Now, this is a stance that was taken despite it being clear that there may well be, as indeed there undoubtedly was, a statutory duty to refer the allegations to the Royal Military Police. For example, sir, on the 7th of April 2011, N2108 sent an email to 1466 regarding what was said to be when there is an obligation on a commanding officer to report matters to the service police to investigate allegations. The email observed that the obligation to report potential offences under the Armed Forces Act of 2007 arguably is a pretty low bar, and it is possible that second-hand accounts from persons or written records which suggest to a reasonable person that an offence may or may not have been committed would trigger that obligation. N2108 went on to say this: in these cases, it is arguable that, taken in isolation, each operation does not meet the statutory criteria for notifying the service police. However, it was said, it is arguable that when all these cases were taken together and there's an identification of similar trends and a suspicion developing over the credibility of accounts given in the operational summaries, then the circumstances are such that a reasonable person would consider that service offences may have been committed. So it's, in our submission, plain that the obvious pattern of conduct gave rise to an unarguable obligation to refer the incidents to the service police. But equally, the facts of the many of those individual incidents by themselves gave rise to precisely the same duty. And that would have been, most definitely should have been, known to the relevant individuals. And this failure to report any of the instances, despite everything that I've identified, and sir, as you know, there is plenty more, is particularly astonishing in the light of the fact, right near the start of the period in which this inquiry is concerned, an RMP investigation called Operation Pavo was initiated into the suspicious killing in September 2010 of an Afghan detainee by an SAS soldier. And that referral came about from an SAS legal advisor following the interrogation of an Afghan detainee. The detainee was shown a photograph of another Afghan man who had been killed by an SAS soldier, and he reported he'd seen that man captured, handcuffed by the SAS, rendered hors de combat, and his subsequent death was therefore alleged to be a murder, and an RMP investigation in Afghanistan was commenced. Now, whilst this investigation ultimately floundered, being closed in 2012 with no referrals for prosecution, it may be thought remarkable that throughout 2011, despite knowledge of a live RMP murder investigation arising in strikingly similar circumstances, no member of the SAS chain of command raised the many other suspicions of killing with the RMP at the time they were investigating the killing covered by Pavo. So they know Pavo is investigating an allegation of an unlawful killing by the SAS after an individual has been raised hors de combat. They know about other instances of a strikingly similar nature. No one ever raises that with the RMP during the lifetime of Pavo. Not only officers, nor did senior Special Forces lawyers, who would have been obviously fully aware of the terms of the Armed Forces Act. Now, the reason for this persistent, widespread failure of officers and the senior forces lawyer in preventing information about suspicious incidents from being referred to the RMP are plainly, we would respectfully submit, sir, matters for which your inquiry will need to give careful and anxious scrutiny to. And that takes me, if I may, to the 2011 TTP review, which may be said to amount to an investigation by the Special Forces into the allegations that were being circulated and ventilated at the time. So, as I'm going to show you, it was nothing to the sort, or you may well conclude after careful consideration of it, it was nothing to the sort, and indeed properly analysed, you may well reach the conclusion that it was an attempt to obfuscate, not to investigate. So I don't know if you want a short 5-minute break before I turn to it. I'm entirely in your hands.
No, thank you, Mr. Hermer. Let's press on, shall we?
Of course. So, sir, instead of reporting these suspicions, the Special Forces commanders instead commissioned what was a brief and predominantly desk-based review of the supposed tactic, technique or procedure, TTP, of sending Afghan men back into compounds which had been cleared already by the SAS. And the TTP, as we have all seen this morning and in the opening of my learned friend Mr. Glasgow, is a recurrent feature of the official accounts of many of these instances. According to those accounts, the routine outcome of the use of this TTP was for a man to be sent back into the compound, having been detained, and would then suddenly produce hidden weapons behind a curtain under a table, and then be shot by the SAS and before those weapons could be used in self-defence. Shot in self-defence by the SAS. Now, I've already touched on the implausibility of the frequency of that account and other features of it that were causing such concern up the chain of command. But it may be thought that if the routine result of TTP was genuinely that an unarmed person who had been detained and was in the control of British forces would be given the opportunity to covertly take up arms and attempt to kill British soldiers, it may be thought it is most doubtful that that technique would ever be adopted as standard practice by the British Army. Why apply a technique if it is constantly leading to Afghan males who were once being held safely, being given the opportunity to arm themselves and potentially kill the SAS? You may ask yourself, sir, how plausible is that? Now, the TTP review was commissioned, conducted and concluded in the month of April of 2011. It involved what on any view was an entirely cursory examination of 11 incidents which occurred between the 30th of November 2010 and the 1st of April 2011. It's a 4-month period. And those 11 instances selected for the TTP did not purport for one moment to be comprehensive. They were, in its own words, examples drawn from pre-existing records held at HQ, which were used to illustrate the review. And there was no particular reason that they, rather than any other incident in which the same TTP was said to be relied on, were chosen. An initial desk-based review of those incidents was completed by one soldier with the cipher 1466 in about half a day. He then gave a verbal briefing to his supervisor, 1802, the Director of Special Forces, who directed a further review be undertaken and set about the terms of references. Now, I want to make a few points, if I may, sir, about those terms of references. Firstly, they were expressly premised on an assumption that all of the killing in the relevant instances were lawful, and that the official SAS account of those instances were truthful. The terms of reference record that. They say that between April 10th of December and between September 2010 and April 2011, there have been several instances in which the subunit 1 had been forced to engage and kill the nominated Afghan male because he had reached for a concealed weapon in the accommodation area. Thus, sir, the TTP review was expressly mandated to proceed on the basis that all the killings by the SAS had been lawful and truthfully recorded in the subsequent post-incident reporting. Secondly, the terms of reference included examining, is the TTP still appropriate to provide protection to the subunit, and whether there has been a change in reaction by insurgents to the TTP. So, in other words, they sought to focus on the protection of the SAS soldiers responsible for the killing. They did not include any requirement to consider whether the TTP was being used to commit extrajudicial killings, i.e. what the reputable international organisation had described as a manufactured self-defence scenario. Or did those terms cover any assessment of any cover-up? So despite everything that's leading to this TTP, despite all the evidence of concerns that I've shown you, these are the terms of reference. Thirdly, the terms of reference required the final report to be submitted by the 20th of April 2011. That is just 9 days after the terms of reference are set. And fourthly, the evidence shows that the Director of Special Forces, N1802, was closely involved in the drafting of the terms of reference. He made, it is said, I quote, word-by-word changes, close quote, before, open quote, authorising release, close quote. Now, after the terms of reference were set, sir, another Special Forces soldier, cipher 1788, was deployed to Afghanistan to assist in the conduct of the TTP review. It so happened that he had been the commanding officer of Sub-Unit 1, whose activities he was now charged with investigating. Not only that, it transpired he travelled to Afghanistan to conduct the review, as you've heard from Mr. Glasgow, in the company of the commander of that same subunit which was responsible for the shooting incidents which were the subject of the review. The two men, the reviewer and the officer in charge of the subunit whose actions were being reviewed, flew out to Afghanistan on the 14th of April 2011. That's just 6 days before the final report was due to be submitted. On any view, sir, these were clearly not conditions designed to result in a rigorous and effective quest for the truth. And we would be most surprised if ultimately the Ministry of Defence were to seek to persuade you otherwise. Now, according to documents disclosed in the public law proceedings by the MOD, the review on the ground conducted by this officer consisted of, open quote, consisted of visiting and speaking to a number of personnel within the subunits, close quote, at the headquarters of UK forces in Afghanistan. So no investigatory interviews were conducted. Instead, the review apparently took the form of a series of informal conversations. For example, 1788, open quote, discussed the use of TTP during call-out, close quote, with the commanding officer of the subunit. During that discussion, N1788, open quote, explained to that officer that whilst measures taken to improve force protection were understandable, there was both a professional and presentational issue with a scenario in which, having gained control of the target premises and its associated personnel, one subsequently lost that control to the point where the previously detained insurgent could pose a threat. I asked him if things could be done in a more effective way. 1141 seemed surprised but took on board my perspective, close quote. The investigator also spoke to a number of commanders collectively who agreed with that opinion of N141 and who said that they thought the unit was doing a good job and that their TTPs were appropriate. Now, the final report, sir, of the TTP review was produced as intended on the 20th of April 2011. The report was officially authored by the in-theatre commanding officer of the unit involved. It uncritically accepted the accounts of the various operations provided by the soldiers who were responsible for the killings. That Afghan men previously detained by them had repeatedly then managed to arm themselves and posed a direct threat to the unit, prompting their death. The report stated that the increased number of deaths that resulted from this was, open quote, unintentional and unwanted, close quote, and it added that there was, open quote, a possibility that cornered insurgents have deliberately chosen to damage ISAF, government of Afghanistan, reputation amongst the local and wider populace by forcing a kinetic engagement, close quote. In other words, sir, the report concluded that all of the 54 Afghans killed during the 11 incidents had brought death upon themselves and may indeed have deliberately sought to provoke a suicidal confrontation with British forces in order to damage the reputation of ISAF in the area, and that this outcome was entirely unintended and undesired by the SAS soldiers who pulled the triggers on those occasions. Now, so when seen in the light of the evidence which I've already summarised, including the numerous expressions of concern about extrajudicial killings, and the fact that there was indeed at that stage a live murder investigation underway by the RMP in Afghanistan, these conclusions are manifestly, we would submit, unsustainable. And it is difficult to characterise them, and indeed we would submit the whole TTP review exercise as anything other than an attempt to suppress, or at the very least turn a willful blind eye towards, the extensive and compelling evidence of a pattern of extrajudicial killings during this period. Indeed, it is telling that Operation Northmore was subsequently presented with evidence that there was a general feeling and concerns within headquarters in 2011 about the behaviour and activity of the subunits, but no investigation took place. It was believed that the TTP review was a thinly coded message from headquarters in the UK to the subunit to stop their activities. In other words, sir, senior commanders at Special Forces Higher Headquarters knew, or at least strongly suspected, that the SAS had committed numerous extrajudicial killings in Afghanistan, and that they sought to use the 2011 TTP review as an oblique means of encouraging the subunit to cease that behaviour, whilst deliberately preventing the true circumstances of those murders being referred to the RMP or otherwise being exposed to independent scrutiny. You may conclude, sir, after carefully considering the terms of reference of the TTP and its conclusions and the context and timing in which it falls, you may well conclude, we would say, that it was no more than a carefully managed device or a charade to conceal rather than to expose the truth. So you will no doubt consider that when you look at the evidence in the round. Irrespective, sir, of the credibility of its findings, it's clear that the TTP review was not intended to be a comprehensive review of all the incidents of concern. It was a short and selective review of the efficacy of an operational practice. Whatever the intentions of those who commissioned it, it did not bring to an end the pattern of extrajudicial killings, which continued for well over 2 more years. And it would, in our respectful submission, be preposterous to contend that it put an end to an obligation to report the concerns to the Royal Military Police. At least 2 directors of Special Forces were aware of the 2011 TTP review. As Mr. Glasgow explained on Monday, N1802 commissioned the review, received a copy of the final report and wrote to the subunit concerned. 1802's successor, Witness P, took over as the overall commander of Special Forces in early 2012. That's midway through the period in which your inquiry is concerned, sir. Now, according to a witness statement that Witness P provided in the Norzai Judicial Review proceedings, he became aware from an unspecified HHQ staff member or members that during 2011 there had been a review into tactic, techniques and procedures used by the subunit, which had been initiated in response to a potential increase in Afghan civilian casualties. Now, according to Witness P, N1802, whom he was replacing as director, didn't mention this in his handover, and Witness P didn't recall any details about the review. And he also claimed that although, in his words, I knew 1802, 1785 and others who all knew about the concerns and the allegations in 2011 to 2012 and remained in touch with them, none of them ever raised these matters with me, nor did 1803 in post as Assistant Chief of Staff during my time as tenure as Commander. And Witness P claims in his statement to find it surprising he wasn't briefed on these issues relating to any of these matters that had arisen in 2011. Witness P also claimed in his witness statement that he does not recall any specific allegations of extrajudicial killing by UK Special Forces on nighttime operations. Now, sir, you may consider, when you come to look at this evidence, that it is surprising that he doesn't recall any allegations that his forces were carrying out what would amount to grave breaches of the Geneva Convention, given that he was overall commander at the time of several incidents which involved potential EJKs, 2 of which resulted in an RMP investigation. The inquiry may wish to consider carefully whether Witness P's evidence is truthful and accurate. If it is, then it may follow that there was a striking lack of curiosity on the Director of Special Forces part, witness P, regarding the context, purpose and scope and outcome of the 2011 TTP review. A lack of curiosity which you may consider difficult to reconcile with his role as commanding officer in overall charge of the Special Forces whose conduct was the subject of that review. If his evidence is true, you may consider it was also follow that it is equally surprising failure by multiple senior UK Special Forces officers to communicate highly pertinent information about potential extrajudicial killings by Special Forces to the new commander of those forces. That failure may be thought particularly surprising in view of the extent of those senior officers' knowledge of potential wrongdoing and their extensive communication, some of which we have seen, regarding those allegations in 2011. If witness P's evidence is not truthful and accurate, then this would strongly indicate an attempt to cover up the extent of his own knowledge of suspected wrongdoing by UK Special Forces and to conceal his own culpable failure to notify the Royal Military Police of this. The knowledge and conduct of those at the top of the Special Forces chain of command, we would respectfully submit, sir, is a critical issue in this inquiry. The inquiry will therefore need to ask itself, did the outgoing Director of Special Forces deliberately withhold important details from his successor, or has his successor been less than candid about the extent of his own knowledge? If information was withheld, or inaccurate evidence has been provided, what are the reasons and the motive for that? And why was neither man ever interviewed by Operation Northmoor in relation to these matters? So we took great comfort from your observations in your opening remarks and from the submissions of my learned friend Mr. Glasgow that this inquiry will not shy from an effective and rigorous investigation of the actions of relevant individuals, whoever they are, how high placed they may be or may have been. We take great comfort from that. So I was going to turn next, that's all I wanted to say about the TTP review. I was going to turn next to Operation Sestro, which is the which was the investigation by the RMP arising out of the deaths of the Norzai raid. So it was the 18th of October 2012, as I outlined earlier this morning, when 4 members of the Norzai family, 3 of them children, one of them a young adult of 18, were killed by the SAS. Their families say whilst they drank tea in the compound. Complaints on behalf of the family were swiftly raised by UK-based lawyers acting on their behalf, and on the 7th of November 2012, an RMP investigation codenamed Operation Sestro was commenced. Operation Sestro was, however, materially hampered, you may find, by a lack of available evidence consistent with a pattern, you may find, of cover-up. Let me identify some evidential sources for that allegation, which no doubt the inquiry will carefully consider. Firstly, for unknown reasons, body cameras were said to have not been in use by the soldiers who took part in the operation. Secondly, intelligence, surveillance, target acquisition and reconnaissance video of the incident, which was in existence, was said to be no longer available, having been overwritten. The footage was apparently said to have been lost as a result of a formatting the external hard drive. And so you will know this is one of several times in which the RMP's investigations in Operation Pavo, in Cestro, in Northmoor, were impeded by what you may consider to be mysterious, indeed suspicious, deletion of critical digital evidence. As noted by the RMP, how could so many things go wrong with one aspect? And in Northmoor, of course, when one's thinking about the retention of evidence, nobody disputes, or there can be no serious dispute, that this is an event that involves the shooting of children. So the deletion of relevant surveillance material. Thirdly, the RMP was not provided with access to the weapons allegedly recovered at the scene of the incident. They were first told that an Afghan officer with the cipher 05 was not allowed to give them the weapons because he was not allowed to handle them. Major Shifa, the officer conducting the investigation from the RMP, then reported that they'd been told that the person from whom she was due to retrieve the weapons doesn't have the items, I quote, doesn't have the items due to, and in parenthesis, confusion. Notes Major Shifa with an exclamation mark. On the 30th of March 2014, this is now a year and a half after the investigation commenced, Major Shifa was told that the weapons would be available from the 7th of April onwards. But on the 3rd of April, the RMP was informed that the weapons had been, open quote, recycled or sold for parts, close quote, and were therefore, obviously, said not to be available for investigation. Major Shifa records this, open quote, they do not have possession of the weapons and has stated they would be recycled if working or sold for parts. And then in her words, unbelievable. So you're going to see a pattern, we would suggest, that requires careful examination of requests, be it for footage or in this case weaponry, by the RMP of materials highly pertinent to any investigation, in which firstly there is a reluctance to hand them over, and when the time has come in which the inevitable must happen and they must be handed over, the materials no longer exist. Footage deleted, weapons sold or recycled. Now, in addition to the weaponry, critical or potentially critical eyewitness evidence was not collected. No attempts were made until April 2013 to interview the two members of the Afghan partner unit. No interviews, in fact, had taken place by February 14 at all, 15 months after the incident, when the RMP discovered, open quote, the two Afghan members who had been present in the guest house at the time of the shooting were respectively dead and brain damaged, such that neither would be able to provide any evidence, close quote. No interviews were ever conducted with members of the Norzai family or the other Afghan civilians who had been present. In terms of the assistance received by members of the relevant sub-units and SAS chain of command, in an email dated the 26th of February 2014, between Colonel Cairns and Major Shifa, of the two of the investigating officers, Colonel Cairns wrote this: I would also formally record my concerns that we are being obstructed in our investigation, or at the very best, SU-14 are not being terribly helpful. Please stay on the case and do not let anyone put you off, close quote. Despite the significant impediments faced by the RMP investigation, in February 2014 it did refer a soldier to the Service Prosecuting Authority, SPA, in respect of 4 counts of murder, contrary to section 116.2 of the Armed Forces Act. The allegation was described in the referral as being that, I quote, on the 18th of October 2012, whilst deployed, he unlawfully killed 4 Afghan males by shooting them in the chest and or head, with his Ministry of Defence Army issued weapon system, close quote. In March 2014, the soldier's commanding officer was also referred to the SPA for a decision on whether to prosecute him for misconduct in public office, negligently performing a duty contrary to Section 15 of the Armed Forces Act, and making a false statement contrary to Section 16 of that Act. That was said to be because, open quote, on the 18th and 19th of October 2012, Lashkar, whilst conducting his duties as an army officer commanding Subunit 4, he authorised the distribution of a storyboard and operational summary relating to the operation, both of which were factually inaccurate, and he either knew them to be accurate or did not take reasonable steps to ensure they were not accurate. And a third soldier, sir, was referred to his commanding officer and then to the SPA for a decision on whether he should be prosecuted for the common law offence of perverting the course of justice by impeding the RMP investigation. As you've heard from Mr Glasgow, on the 5th of March 2015 and from Mr Greeney, the SPA decided it would not prosecute any of the three officers for the offences identified by Operation Sestro. The decision stated, open quote, it would not be possible to disprove the claim by the British soldier who opened fire that he was acting in self-defence. Now, so that decision and the RMP investigation which preceded it approached the incident as if it were an isolated occurrence. They did not consider at any stage the wider pattern of EJK and the impact that the broader evidence may have on the prospect of disproving the claim of self-defence. That's a critical, we would submit, flaw. Both the investigation and the decision not to prosecute occurred in a vacuum, with no regard to highly relevant contextual evidence of a wider pattern of suspicious killings and cover-ups. This included, but was not limited to, the assessment of the probative relevance of other highly germane investigations into unlawful killings, including Operation Pavo and Operation Shiverwood. So if I can give you a lay analogy, which applies to this, and it also applies to the other RMP investigations that you may consider. It would be a little like an investigation into the murders committed by Dr. Shipman for an investigator to focus solely on one death of an elderly patient and not to look at it in the context of the wider pattern. So, as to a more granular critique of Sestro, my learned friend Mr Glasgow referred on Monday to an examination carried out by an expert in forensic examination of firearms who concluded that the marks on the wall were not consistent with it having been caused in a manner described in Mr Norzai's statement. On a proper analysis, we would submit the expert evidence does not contradict Mr Norzai's account. Can I identify three factors, please? Firstly, the forensic analysis conducted was on its face very limited. It was limited to a test firing of the soldier's weapon system, reading what are a small number of statements, and looking at some photographs on an unspecified date. The expert did not, it appears, conduct any forensic analysis of the location or the bodies of the deceased, or whether weapons were alleged to have been found at the scene. Secondly, according to the letter sent by the SPA, the expert concluded that the circular marks on the walls are not consistent in position with having been caused in the manner described by Mr Norzai, And that was said to be that because the circular damage areas are located close to floor level, the low-level damage would have struck the abdomen, and then this, sir, of an average-sized man in a sitting position on the floor. From observing the photographs of the deceased young Afghan males, the majority of the wounds which are visible are located either to the head or the chest, therefore not consistent in position with the circular wall markings. So we would submit that that needs to be very carefully examined because, of course, as you know, the 4 deceased were not average-sized men. 3 of them, at least, were children. And finally, sir, the expert did opine that the markings are not consistent with the reports that she had received from the soldiers involved. And so, as with other aspects of the evidence, injuries to the bodies, weaponry, etc., we would hope that this is a matter to which your inquiry will give careful consideration, if need be, with the assistance of expert assistants. So that's all I wish to say about Cestro. I was going to turn next to Northmoor. If it helps, my promise to Mr. Glasgow that I would finish within the day is one I'm absolutely going to keep.
Thank you, Mr. Hermer. We'll adjourn now till 2 o'clock, please. Thank you.